there any bill introductions? Seems like I was going to have one, but I can't remember. No, I think I'm okay right now. Yeah, I think I'm up to, I thought I was behind, but I'm not. Any bill introductions? Seeing none, we will move on then to our hearing on Senate Bill 394. And this is clarifying signature. Oh, do you have a bill introduction? Oh, Senator Murphy has a bill introduction. We'll go ahead and let him get settled in here. And
sorry, Chair. Appreciate that.
no problem.
People getting out of my office late and me getting out of my office late.
You kick him out of there.
Kick him out. I have, it's a Senate concurrent resolution, RS 2874, in relation to property tax.
Committee, any questions or objections to introduction to that bill? Seeing none, that is introduced.
And also,
okay.
I also have RS 2878. It's an act concerning property tax.
Very good. Any questions or objections to introduction to that bill? Seeing none, that is introduced. Any further bill introductions? Seeing none, now we move on to the hearing on Senate Bill 394, clarifying signature verification. We'll let Jason give us a bill brief. Jason.
Thank you, Mr. Chairman, members of the committee. Senate Bill 394 proposes to make two changes with respect to policy on advanced voting ballots. The first is a change on the language on an advanced voting ballot envelope. So when the voter requests an advanced voting ballot, they receive back both the ballot and an envelope in which to return the ballot. And that envelope has directions on the outside of it, along with signature blocks that need to be completed when it is sent back. Part of that instruction is for when the voter is physically unable to sign and they have someone assisting them in returning their ballot, then there is a block for that, along with an affidavit for the person who is assisting. Senate Bill 394 would expand that to not only individuals who are unable to sign in that signature block, but also those whose signature would be inconsistent with the signature of the voter that is on file at the voter registration database. So if they've registered to vote years ago and they signed their name and that's what's on file, but in their current condition, they are unable to consistently sign their name in the same fashion, so that a voter's signature verification could potentially show a discrepancy, then there would be language for a person to assist them in signing on the envelope and affirming that this is the voter and they're signing on their behalf. So it's an added allowance for voter assistance on an advanced voting ballot under Senate Bill 394. The other provision in Senate Bill 394 is to enact a conditional repealer. These are cases where upon the occurrence of a particular specified condition, then future legislative enactment becomes effective. In this case, it's a conditional repealer, so upon the occurrence of a specified situation, then statutes will be repealed on the effective date of that. In this case, the specific action is a final order or judgment that is not subject to appeal by a court of competent jurisdiction that invalidates or enjoins the enforcement of the signature verification requirements under 25-1124H. The that you have in front of you, I've laid out the provisions of that subsection H. This is a provision that requires a county election officer to verify the signature on an advanced voting ballot that they receive before they accept and count that ballot. If that particular provision is invalidated or enjoined by a court in a non-appealable final order or injunction, The Secretary of State is to publish notice of that decision in the Kansas Register, and on the date that notice is published in the Kansas Register, then all of the advance voting ballot statutes are effectively repealed on that date. And so there would then no longer be a provision for doing advance voting in Kansas as of that date, as all the statutes would no longer be in effect. There is an exception for any advance voting that is required under federal law, such as the Uocava statute for folks overseas. But outside of that, any Kansas resident residing in Kansas would not be allowed to submit an advance voting ballot upon the repeal. This would go into effect on July 1st. With respect to the envelope language change, obviously the repealer is conditioned upon a future court case and future decision by a court, and so those are not repealed as of July 1st this year, but would be on record as being subject to repeal if that situation ever arises. That I'd be happy to stand for any questions.
Okay, committee, any questions? Senator Francisco.
Thank you, Mr. Chair. Jason, I'm talking about the part of the bill that talks about the signatures. And how would a voter know what their signature looks like on file?
I suppose they could request and go down to the county election office and request to see what their signature on file looks like at that point. I'm not sure. Yeah, I think that's a good question for county election officers as to how to handle that day-to-day operational stuff.
Thank you. Mr. Chair, I know that our county clerk has a record of signatures, and certainly there were a lot of changes when we went from using a pen to sign in the book to using your finger or a stylus. But I don't know that you could, if you had used the stylus, it would be hard to repeat that
I couldn't.
on a ballot envelope. Thank you.
It'd be tough. And maybe we'll ask our proponents about that as well. Jason?
Just a quick point of clarification on that signature verification. The language in 25-1124 requires the county election officer to contact the voter to confirm signature. If they look at the signatures and they don't appear to match, there is a confirmation that must be done with the voter before the ballot is rejected and not counted. So I just wanted to point that out.
Senator Fausto, I think, had her hand raised. I don't know if she has a question. Senator, are you online? I don't know. We'll come back to her if she took it down. Did she take it down? Any other questions? Senator Starnes.
Thank you, Mr. Chair and Jason. Just asking about the associated cost estimate to the counties. There would be, I understand Secretary of State's going to use $200,000 to get out more and more information, but then it indicated increased counties' costs associated with this. And just an estimate, anybody have any idea on that? Or maybe someone else is there able to address that, but.
I do not know what estimates have been put forth. I would defer to the Secretary of State's office if they have any information along those lines.
Thank you, Jason.
Any other questions? Seeing none, thank you, Jason. Appreciate it very much. We have proponent in-person testimony from Clay Barker, Secretary of State's office. I'm just going to set a block time of about 12 minutes here for both sides. And Clay, the floor is yours, sir.
Thank you, Mr. Chair. Good to be back in Senate, Fed, and State. Clay Barker, General Counsel, Kansas Secretary of State. And I'll briefly go over the bill to explain what it's doing. The Section 2, the first part Jason discussed, what that really does, in essence, is it makes some statutory language in 25-1121, which describes what goes on the envelope, consistent with the requirement in 25-1124. And 1124 was adopted later than 1121. There was a slight inconsistency in the language, and now they're going to say exactly the same thing. So the envelope and the two statutes will all match. That's a pretty minor statutory amendment. Now, the main new Section 1 is the one that'll get the attention. So I want to start out by saying this idea was given to us by the Colorado Secretary of State in litigation they had. It did not come from a nonprofit organization, and it's not a partisan issue. And Colorado had the same issue that Kansas is doing, is there's a litigation challenge to the entire concept of signature verification. And what Colorado's courts did is they examined the issue and said, the trial court said, if signature verification is enjoined, their entire mail balloting stops. And their appellate court and Supreme Court did not change that holding. And that caused the litigation to go away. It was dismissed immediately. So what this statute does, instead of allowing the legislature to go through the issue, is it allows, so the judiciary does not go through the issue. It allows this legislature to lay down a line that says if a court is to invalidate signature verification is so intertwined with the rest of mail balloting, it's not severable. It cannot be taken out. And it would cause all mail balloting to stop until a new remedy is given. So what it does is it sets legislative intent to unambiguously establish, which is certainty and beyond dispute, that signature verification is not severable because it's intertwined with everything, the application, the ballot. You can't even open the envelope until the signature is verified. Now, Kansas has one of the best procedures for signature verification in the nation. Its regulations were designed around every single court case that has looked at signature verification, and it exceeded those standards. It has uniform statewide procedures that are based on objective data for verification, and it is supplemented by robust due process. So at least two people have to decide the signature is not consistent with the one on file. There are multiple attempts to contact the voter, and the voter can come back and cure the signature or say, yes, that is my signature, and the ballot counts. And just so you know, the impact of signature verification in the 2022 and 2024 general election, we have to give data to the federal government of about 300,000 mail ballots that were returned. Only in the end, about 224 were rejected because the signature was inconsistent and the voter did not come back and cure it. So we support this bill strongly. I think it lays down the legislative intent that signature verification is so integrated with mail balloting that it cannot be pulled out separately and stopped. And with that, Mr. Chair, I'll stand for questions at the appropriate time.
Thank you, Clay. We have one other WebEx proponent, so we'll go there, and then we'll open up to questions for either Clay or our next proponent, which is Christian Adams with the Public Interest Legal Fund. Christian, online, are you there, sir?
I hope you can hear me, Mr. Chairman.
We sure can. Go right
Good.
ahead.
Thank you. I'm J. Christian Adams. I'm president of the Public Interest Legal Foundation, which is a charitable law firm that litigates for election integrity. I'm also a commissioner on the United States Commission for Civil Rights, a presidential appointee, though I don't speak for the commission today. Thank you for the opportunity to submit testimony in support of SB 394. It is an important issue about how Kansas verifies the identity of voters. A ballot cast by mail and a ballot cast in person are not the same thing because one enjoys the direct oversight of election officials and the watchful eye of polling place observers and a rigorous process at the voting site. A mail ballot does not. In fact, voting outside of a polling place is the most vulnerable sort of voting by far. Absentee voters, mail voters can be abused, defrauded, intimidated, and tricked. I know this because I've witnessed it firsthand. I would urge you and your staff to read the federal court decision in United States versus Ike Brown and submit it into the record if you might. I'm sorry, I thought I heard someone. The citation is in my written materials. I worked on this case when I was an attorney at the United States Department of Justice in the voting section. In short, a wrongdoer was forging signatures on mail ballots they signed for the voter. We discovered this because at the Justice Department, we could see voter signatures and witness signatures that appeared to be from the same person. Anyone who tells you that absentee and mail voting is secure hasn't read this case. Voters were visited by operatives who took and cast their mail and absentee ballots. the voters sometimes turn them over because the wrongdoers were powerful or even well known in the community. Kansas can bring a measure of confidence to mail voting with this Senate bill and the use of signature verification, because it's the principal safeguard that allows citizens to vote by mail while maintaining confidence for both the voter and the public. Kansas should reform any mail voting statute if any court strikes down the signature verification requirement, because mail voting should not be allowed without signature verification. Thank you. That's all I have.
Thank you, Christian. Committee, we do have written testimony from Missy Levitt, Justin Reimer, and Debbie Detmer. So at this point, I'll open up for committee questions for the proponents. Committee, any questions? Senator Francisco.
Thank you, Mr. Chair. I think this is for Clay Barker. So this change on the having the voter or another person be able to help a voter if they're unable to sign only comes into effect when that individual needs that help. So there will still be times when a voter may be unable to sign the envelope consistent with their vote on file, but that would be handled differently. Make any sense?
Yes, Senator, and so that requirement is already in law in 1124. That was the bill I believe Senator Hildebrand carried a few years ago. And that requirement was a little inconsistent with the older language of 1121, which tells you what goes on the ballot. So this has been in that requirement that you can, when you sign it, you're saying either I can't sign it or I can't sign it consistently because of a disability or hand shaking. It's just to let the election staff know that's what's the problem. And then they can, I'm sorry, Senator.
Okay, but thank you. But this talks about having another person also there to verify that.
Verify that, yes, Senator.
So what happens if you're just at home and you don't have another person? You just wait till they say it's inconsistent and try to cure that ballot.
That would be one option, Senator, or try to find someone that can help you out. Usually people with disability have some caregiver that's helping them if they're just unable to sign.
Committee, any other questions? Seeing none, thank you, Clay. Thank you, Christian. We have no neutral testimony. We do have opponent in-person testimony, and we'll also give a total block of 12 minutes. First up is Logan DeMond of ACLU. Logan, welcome to Fed and State.
Thank you, Mr. Chair, and good morning, members of the committee. My name is Logan DeMond, and I'm the Director of Policy and Research at the American Civil Liberties Union of Kansas. We're a nonprofit, nonpartisan organization with more than 35,000 supporters across the state that works to protect and strengthen the civil rights and liberties of all Kansans. We're here today because we oppose Senate Bill 394, which relies on signature verification rules that have led to disenfranchisement and threatens to eliminate mail-in voting altogether if courts intervene to protect those voters' rights. And you all have my written testimony, so this morning I'll focus on our biggest concerns with this bill, the first of which is the disenfranchisement associated with signature verification. As has been pointed out, signatures vary. They don't always match. We can all agree on that. The way we sign one thing might be a little different than the way we sign another, especially for people with disabilities, people with degenerative diseases, individuals with visual impairments. And although this bill does address some of those discrepancies, litigation has shown that mismatching discriminates against these folks, as well as those who are transgender, women who have changed their names when they get married or get divorced, those who speak a primary language other than English, and voters who are voting overseas as well. This places the additional burden of curing on the voter to come back and address that discrepancy instead of making it easier for eligible citizens to vote. This is erecting a new barrier, essentially. Voters have challenged this process not because they want to cheat, but because it is unreliable, it is arbitrary, and it is discriminatory. And that's exactly why the courts step in. Now, I understand that some folks are going to say that if this system is broken, the only logical solution is to scrap mail-in voting altogether and start anew. But here's why that's not the answer. Courts intervene to ensure the implementation process is being followed. They're not attacking the mail-in balloting process when they do so. But if this bill has its way, Constitutional challenges will be used as a proxy for ending mail-in voting altogether. Why is that bad, some might ask? Because people of all stripes rely on mail-in voting. Whether it's because they're elderly and they can't get to the polls, they have a disability, they're a student studying out of state. Instead of scrapping everything altogether, we should be focused on legislation that creates clear and uniform standard for review of these signatures, as well as improved training and resources for election officials to reduce these arbitrary mistakes, and instead focusing on preserving mail-in balloting. In conclusion, Senate Bill 394 does not attempt to fix the problems with signature verification. It's looking for an easy out. It threatens voters for being protected by the courts. This is a retaliatory approach that threatens to eliminate mail-in voting altogether, including the 120,000 Kansans who did so in the 2024 general election, if the courts intervene to protect this process. This forces voters to accept a flawed and discriminatory system or lose mail-in voting altogether, and it is a recipe for voter suppression in doing so. When the opportunity presents itself, I respectfully encourage the members of this committee to oppose Senate Bill 394. I thank you for your time, and I will stand for questions at the appropriate time.
Thank you, Logan. We'll finish the block of opponent testimony and then open for questions. Up next, we have Seal King of the League of Women Voters. Seal? Is she WebEx, Messiah? No. I do not see her in the room. Finally, we have Rabbi Motai Reber, Kansas Interfaith Action. Is the rabbi here this morning? I do not see him. And not on WebEx, correct, Messiah? Okay. I guess we will close the hearing then. Any questions? Yeah, questions for Logan, I'm sorry. Jumped ahead of myself. Senator Francisco.
Thank you, Mr. Chair. So I understand that you are urging the committee to not pass this bill. Do you have different comments on Section 2, if that were the only piece of the bill that was under consideration?
I apologize, Senator. I do not have a copy with me today. I failed to print that.
Section 2 has to do with conforming the signature verification if they don't conform.
I think the most important thing when it comes to the signature verification process is the flaws that we pointed out. That this is not a magic fix. Instead, there needs to be stronger standards in place to ensure that it is not discriminatory, that is consistent across the board. And I think the biggest flaw with this legislation is that it's saying if the courts do intervene to enforce these protections, we're going to scrap the system altogether.
Thank you, Mr. Chair. That's why I separated my questions from Section 1 and just asked you to focus on Section 2. Section 2 may not be that magic thing that makes everything make sense, but it seems like it does add some consistency and the ability to have a record that someone, although they were able to sign their signature, was not able to sign it in the same way it may be on file with the clerk. So that, do you not see that as a step forward?
I think it's a step in the right direction. Like I said, though, the biggest flaw here is if there is still any discrepancies that exist, if the courts do have to intervene, the risks outweigh any benefits of this legislation.
Senator Clifford.
Thank you, Mr. Chairman. In your testimony, and I'm reading the written testimony, I'm a physician, so I appreciate what you said about this impacting people with disabilities, the elderly, people with degenerative diseases, and especially individuals with visual impairment. But in your oral testimony, you added the idea that transgender people would be harmed by this, and would not a person who just chooses to be a different gender legally change their name? So I don't understand how they are included in this armed group.
Yeah, thank you for the question, Senator. When I mentioned transgender Kansans, it's important to remember that this is placing an additional burden on these folks if this process is triggered to come back and say and address that discrepancy themselves. That's why we included them in that class of individuals who could be discriminated against.
Thank you.
Senator Tyson.
Thank you, Mr. Chairman. I do have a couple of questions. I'm looking at the testimony, the written testimony by one of the proponents, and they basically said that the acceptance of the, I mean, this is common sense legislation. Why wouldn't we implement something to protect validating the signature of the person? And for, well, then I have a follow-up if I may, Mr. Chairman.
Would you like to respond, Logan?
Yeah, so the question is, why wouldn't we do something like this? I think it's important to remember that courts do not intervene lightly in election law. This is not doing anything to strengthen election integrity. Instead, it is disenfranchising voters without due process because it is saying that if the courts do intervene, we're going to toss out everything altogether.
Senator Tyson, follow up?
So your argument's not against the common sense legislation. It's against what could potentially happen.
I think this legislation is focused on what could potentially happen if this system is triggered and if the courts do have to intervene, yes.
So if I may, Mr. Chairman, I find it offensive that you would say that this is prejudicial against one group or another. How do they know what you are based on your signature?
Mr. Chairman, if I may, and Senator, I want to apologize if I have offended anyone on this committee. It is not the signature itself that they are discriminating against and saying this is the name, and so therefore we're going to target this individual. I'm saying that focused on the litigation that has played out, there are clear trends that have developed in who is being discriminated against.
If I may, Mr. Chairman?
Sure.
So who is discriminating? I know my county clerks would be completely offended by your comments. They are not discriminating against anyone. So who are you insinuating is discriminating?
I'm talking about the voters who are being attacked by the signature verification process. This process identifies these individuals who happen to fall into these very specific categories.
So if I may, Mr. Chairman, we have reached a point where we are trying to validate signatures and being accused of, I just think this is common sense legislation. Thank you, Mr. Chairman.
Any further questions? Seeing none, thank you, Logan.
Thank you.
Comment by Senator Thomas? Yes.
Yeah, I think it's very telling that we have one side arguing on this bill based off assumptions and one that was able to get up and cite actual court cases to support their argument. It's not discriminatory at all. And I think, I agree, this is good common sense legislation. And signature verification is already the law, if I understand correctly. So this is not, that's not even the issue with this. It's basically just happens to do with what happens if the signature is struck down. So I think that's worth pointing out.
Senator Murphy.
Well, thank you, Chair. And I would echo that in the sense also that the purpose of all this is to assure that your vote is counted. And if you have problems in this process, your vote might not be counted in the sense of your vote gets canceled out by somebody where a ballot that didn't belong in there cancels you out. So I think it's important. If we're talking, election integrity, making sure your vote counts, I think this is important.
Any further questions or comments? Seeing none, we will close the hearing on Senate Bill 394. Committee, that's all the work that we have today. We do have a hearing on Senate Bill 261 tomorrow. We have a 356 on Wednesday, which is a firearms bill. I may add, because we're turnaround is rapidly coming, I may add a bill hearing on Thursday so that we can get that. But these bills, and then we've got some to work that shouldn't take too long. 310 on the crypto, 1617 on the convention or Article 5, 355. Those are outstanding bills to consider to work. We'll just kind of see how our days go here this week and keep things moving on. So thank you very much for your hard work, and we appreciate it. And with that, we are adjourned.